Please be seated. Next matter is 25, CRV 1536, State of Ohio versus Jason Marsh. Mr. Marsh is President of Council, Mr. Laughlin, and Mr. Nicodemus is here on behalf of the Village of Buckeye Lake. We're scheduled for a change of plea in this matter. Mr. Marsh is charged with disorderly conduct, I believe, or are we amending it to disorderly conduct?
To DV and assault.
Okay. Okay, Mr. Laughlin, does he wish to plead to those charges? What are we doing today?
Absolutely not.
Okay.
I thought this was amended to a disorderly so we could try for ILC or waiving ILC. That's what it was originally set for. It was an ILC plea hearing. When he missed that hearing, which obviously it would have been possible to the DV or assault. The complaining witness here is not cooperative. It's his mom. She's not pushing for a DV or assault. Ed Itam was the attorney and took over this case about a month and a half ago. The understanding that nothing's changed.
Okay, my understanding was there was an offer to do ILC, and if ILC was granted, to amend to a disorderly conduct so that it could be placed on ILC.
Okay.
That did not occur. And then I got an email that we were pleading to it. There's no other discussion about pleading to a disorderly without the ILC. I am in contact with Mom. She is out of state. She's a party to another case and have a motion to she'll participate via Zoom if the court will permit it. And I did get a statement from her about this. So she is cooperative. She does want to see him get help and be accountable. But it was never my intent to make it a disorderly conduct without the ILC.
Okay. Can we place it back on the trial schedule?
Yes.
Okay.
I'm not pleading to that. She's watching right now. She's literally watching right now. I've been in more recent contact with her than anyone.
Okay.
Not sure why it would ever be amended only once ILC is granted. That's not even. That doesn't even make sense. What would he plead guilty to then?
Excuse
He
me.
can't plead guilty to a domestic and be granted ILC.
That was the
Correct. That was
the deal.
condition.
Was if he was eligible, if he was eligible for ILC, then he would amend the charge. That's what he's saying.
He is, of course, eligible for ILC outside of pleading to the domestic itself.
But we don't have an ILC assessment.
We are foregoing our opportunity for ILC because he's going to Mended Reeds tomorrow. And ILC, when I reached out to LAP, was going to take multiple weeks. Why would I go for ILC on a DOC that can just be sealed and expunged? And we already have a mental health plan in place. There's no extra benefit to it.
Okay, I'll place it back on the trial schedule.
He's getting picked up by Mended Reeds tomorrow. We've been trying for this for weeks. What are you doing? Why would you not amend it to a DOC here right now today?
Mr. Laughlin, you can go out in the hall.
Huh?
You can go out in the hallway. This is not how we're going to behave in the courtroom.
What do you mean? I don't know what you mean. I'm talking to the prosecutor.
No, you're not talking to the prosecutor. You've cursed through fit, and now you're berating the prosecutor.
Cursed?
If you want to,
I didn't curse at anything.
you did. You multiple times.
What curse did I say?
Okay.
This is a round show. Sit here alone.
Woo! Yeah, he did curse. He cursed under his breath. I mean, I heard it. He dropped the F-bomb. I think he said, I don't know. I don't want. Yeah, he said a few things. But yeah, and then I don't know if you heard him, but he's like, "This is a public courtroom. I can sit here all I want." Like, yeah, the judge just asked you to leave. You called it a clown show. Yeah, the only reason it's a clown show right now is you're not held in contempt for what you just did. Anyways, he's back. They called him back on the record. I guess they calmed. I don't know. They were speaking, so we do have a part 2 to this. Let's go.
Please be seated.
Look at the attorney's body language right now. He's screaming, "I'm a child. I didn't get my way." Meh. I mean, just look at him.
Next matter is 25 CRE 1536, State of Ohio versus Jason Marsh. Mr. Marsh is present counsel. Mr. Laughlin, Mr. Nicodemus is here on behalf of the Law Director's Office. We're scheduled for a change of plea in this matter. Mr. Marsh, is it your wish to change your plea to guilty here today?
Yes, Your Honor.
You understand that a guilty plea is a complete admission of your guilt?
Yes, Your Honor.
Okay. Did you sign this change of plea form?
Yes.
Did you understand it?
Yes.
Okay. You understand by pleading guilty today, you're waiving your right to a trial, either to a jury or to the court.
Yes, Your Honor.
And did you sign this waiver of jury trial form?
Yes, Your Honor.
At a trial, you'd be able to call witnesses to testify on your behalf, subpoena witnesses to force them to appear here and testify, and present evidence in your own behalf. You understand you're giving up those rights today?
Yes, Your Honor.
You understand you're giving up the right to question any witnesses that the state would have against you.
Yes, Your Honor.
And finally, you understand you're giving up the right that the state prove beyond a reasonable doubt you did in fact commit these offenses.
Yes, Your Honor.
Mr. Laughlin, you and Mr. Nicodemus recount the facts today.
Yes.
Okay.
Hey, on or about November 24th, 2025, approximately 11:41 a.m., officers were dispatched to 47 Lot K10 in the village of Buckeye Lake, Licking County, Ohio, on a domestic dispute. The call was from the property manager. Upon arrival, officers encountered Roberta Marsh and reported an argument with her son, Jason Marsh, and that he had physically assaulted her. Roberta was identified outside in the front lawn. The defendant was there as well. Defendant was hysterical, placed in handcuffs, and stated that the victim had started screaming at him and that he had taken 2.5 bottles of pills, later identified as risperidone, and I don't even know what that other one is. Defendant had a medical condition and ended up being pink slipped out of this, telling officers that he wanted to die. Victim stated that when she was out of town with the weekend, he came back home, made a mess. Prior to the argument, victim and defendant, victim knocked on the defendant's door to ask him for help. He got up, stated that he had pulled his stomach muscles. Altercation began when the victim stated defendant threw a plastic laundry basket at her with clothes in it. Defendant was arguing with the officers and victim while this interview was taking on. Victim stated that this is a recurring issue with him throwing in the past, and that she had been in the process of evicting him. She was hit as part of this altercation. Property manager arrived on scene, indicated that there was a lot of yelling, but that she did not see anything. Defendant was then, as I mentioned, sent to the hospital and pink slipped out of this incident. Defendant was then charged with domestic violence for the altercation inside the house and throwing the laundry basket and striking his mother is their relationship. I do not believe he did any jail time after he was released from the hospital. Understand that there's 15 days of credit on this case at this point.
Thank you. Mr. Marsh, you understand if you were to be charged with domestic violence again, it would be a felony offense?
Yes, Your Honor.
Okay. You understand, once convicted of domestic violence, you'd be prohibited from purchasing, possessing, or transporting any firearms or ammunition?
Yes, Your Honor.
Okay. Do either of those things change your mind about pleading guilty today?
No, Your Honor.
Okay. Based on that, then I'll accept your guilty plea as being voluntarily and intelligently made, knowing what your rights are. I'll find you guilty of domestic violence and assault. Those are merged, I would assume.
Yes, Your Honor.
You have a sentencing recommendation then?
Your Honor, I understand he's got 15 days of credit and has a bed date possibly of tomorrow. It amended reads. There was another case here in Licking County. I believe his bond has been set on that so that he could go to mended reads. And I believe his cases in Fairfield County also have a stipulation of going to mended reads. I believe it's probably in his best interest. And his mother has sent a statement saying that she would like him to go to mended reads. If his bed date is tomorrow, he serve one more day and then be released on probation with a term of going to mended reads so that he can get some help that is needed.
You want me to supervise him with that condition? Is that what you're saying?
Yes, because I don't believe he's on probation yet in any of the other counties or any other cases. So I think it'd be wise to have him supervised.
So he's not going to mended reads out of a guilty finding in Fairfield County?
It's a bond condition.
It's pre-trial. Okay. You have a suspended sentence recommendation.
Your Honor, because he's going to mended reads and we do have some jail time, I'd ask for the just 180 days on this, suspend what he doesn't have credit for, so that we can make sure that there's a carrot and stick that when he gets out of mended reads, there's that incentive to maintain any programming that they recommend and that he has to follow up with.
Mr. Laughlin.
You join the rec.
Good. Mr. Marsh, you want to say anything today?
No.
Okay. So you do have a bed date tomorrow, you said?
Yes.
Okay. They're coming to get him from the jail?
Yes.
$15. Okay, now post court costs 90 days jail, 15 days credit. Place you on probation for a year. Need to abide by any terms set by the probation department. That'll include completing mended reads program. I'll order that you be released to mended reads. I'll order that second count merges with the first count. Any question about that sentence, Mr. Marsh?
No, Your Honor.
Okay. Anything else, Mr. Nicodemus?
Nothing, Your Honor. Thank you.
Thank you.
Even that pulling of the phone. He is lucky that this is Judge George, and I've seen Judge George just get frustrated maybe one time in the, I don't know, year and a half I've been watching him. But man, guy's acting like a child. Anyways, that's all I got. Hopefully you enjoyed this. I did. Hit the like button on your way out if you have not done so already. Also comment, hype, subscribe, do all those fun things. You know what to do. That's it. That's all I got. Till next time. Bye.
This courtroom hearing takes a dramatic turn when an attorney clashes with the prosecutor during a plea negotiation, pushing Judge George to step in and restore order. The disagreement quickly escalates as the lawyer challenges the prosecutor's position, leading the judge to warn that the courtroom behavior is unacceptable and nearly results in a contempt finding. After the situation is controlled, the defendant ultimately accepts a guilty plea, and the court focuses on rehabilitation, sentencing him to probation, treatment at Mended Reeds, and a suspended jail term designed to encourage accountability and recovery.